Imagine this. You walk into work on, I don't know, a random Tuesday, and your boss calls you into an office. The door shuts.
Oh, we all know that feeling.
Right. It's terrifying. And completely out of the blue, you are unfairly fired. Now, if you are like most people, your brain immediately goes to one very specific place.
You want to sue.
Exactly. You probably assume you can just hire some relentless lawyer, march straight into civil court, and sue the company for everything they've got right, because it feels like the natural order of things. You were wrong, so, you go to court.
It does feel natural. I mean, it's a very comforting assumption to make. We instinctively like to think there's just one big universal rule book for fairness in the workplace.
Right, like standard rules that apply to everyone.
Yeah, exactly. We assume that a worker is a worker, a boss is a boss, and the civil courts are just there to referee the whole thing. But when you actually look at the mechanics of Canadian employment law, that assumption is just completely fundamentally wrong.
And that is exactly what we are exploring today. As we create audio overview deep dive content on this topic, we are going to look into the real operational mechanics of Canadian employment law. Because this legal landscape is absolutely not a one-size-fits-all monolith.
No, not at all. It is a deeply complex, incredibly fragmented web.
So what's the mission for our deep dive today?
Well, the central thesis we need to establish right up front is this idea that in Canada, jurisdiction is destiny.
Jurisdiction is destiny. I like that.
It's the absolute truth. The specific jurisdictional bucket that your job falls into dictates entirely what your substantive rights are. So, what you actually get. And your procedural remedies, which is how and where you are allowed to fight for those rights.
So the rules change completely depending on who signs your paycheck.
100%.
Which means if you get your jurisdiction wrong, you might find yourself spending, tens of thousands of dollars fighting a battle you are literally legally barred from winning.
Yeah, and we see that happen. People waste so much time and money.
So let's start unpacking this by looking at the private sector, specifically the federally regulated sphere. Because from what the sources say, this makes up about 10% of the Canadian workforce, and it just completely flips what we think of as standard employment law right on its head.
Right. So to understand why this pocket of the workforce is so different, we really have to look at the way the country was built.
Okay.
Generally speaking, labor law is a provincial matter, but there is this vital constitutional carve-out for federal undertakings.
Like national industries.
Exactly. Think about the industries that connect the country across provincial lines. So if you work for a major bank, a telecommunications company, interprovincial transport, an airline...
Or even something highly regulated, like a uranium mining operation, right?
Yes, actually. Even uranium mining, which, always sounds so intense.
It does sound intense, but it makes complete sense that it's federally regulated given the national security implications.
Right, definitely. So for the non-unionized workers in these specific industries, they fall under a specific section of the Canada Labor Code. And this code gives them a level of job security that essentially mirrors what you would get if you were in a union.
Okay, let's unpack this. Because normally, under standard common law across the provinces, a boss has the inherent managerial right to fire a non-unionized employee at any time for pretty much no reason at all, right?
Yeah, that's what we call a termination without cause. They just have to give you reasonable notice or a severance package, and they can send you packing.
But the federal code changes that.
It does. It creates a specialized, unjust dismissal regime for eligible workers who have over 12 months of continuous service.
I was reading the Supreme Court's take on this, and I found it fascinating, specifically that landmark case involving Atomic Energy of Canada.
Oh, Wilson, yeah, that's a massive case.
Right, Wilson versus Atomic Energy. Because for decades, there was this massive legal debate about whether federal employers could still just buy out an employee, fire them without cause, hand them a big severance check, and just walk away.
And employers really fought to keep that right.
But the Supreme Court definitively shut that down. They ruled that the Federal Labor Code strictly prohibits the dismissal of these eligible employees on a without-cause basis.
The logic there is really important to grasp. The Supreme Court recognized that these amendments to the Labor Code were explicitly designed to give non-unionized federal workers a cost-effective alternative to civil court.
An alternative that actually protects their job, not just their severance.
Exactly. It levels the playing field against massive institutions like banks or national telecoms.
It's like an impenetrable shield. A bank can't just throw a giant bag of severance money at a teller to make them go away if they don't actually have just cause to fire them.
Right.
And the remedies, if the employer gets it wrong, are just a complete paradigm shift compared to regular civil court.
Oh, completely.
Because if an adjudicator decides you are unjustly dismissed, they don't just calculate your severance. They can order full retroactive back pay, substantial indemnity costs, and this is the most striking part to me, actual physical reinstatement.
Yeah, they can legally force the company to give you your desk back,
Ugh.
which is virtually unheard of in provincial civil courts.
It is a radically different landscape. But as we'll see with every one of these jurisdictional areas, there are very specific hard boundaries on who actually gets this protection.
Always. There's always a catch.
Right. Which brings up a skeptical question I have. Because managers are explicitly excluded from this federal unjust dismissal protection.
Yes, they are.
If they are fired, they are just back to relying on regular severance. So what stops an employer from engaging in simple corporate trickery?
What do you mean?
Like, can a telecom company just slap the word manager on an administrative assistant's email signature to strip them of these federal rights?
It's a great question, and it's a tactic that companies have certainly tried to use.
I bet.
But the courts are very wise to that exact trick. There is a strict legal test that adjudicators use, often tracing back to the Canadian Pacific Railway versus Katz decision. And under this test, they completely ignore corporate job titles.
So the title on your business card is entirely irrelevant.
Irrelevant. They only care about the operational reality of your day-to-day role.
Okay, so what actually makes a real manager in the eyes of the law then?
Well, a true manager must possess the power of independent action, autonomy, and discretion. They need the final authority to make fundamental administrative decisions.
So things like hiring and firing.
Exactly. Can they autonomously hire, fire, and discipline staff? Can they independently commit the company to significant financial obligations or, set departmental budgets?
And if they can't?
If an employee, even one with a very fancy director or vice president title, lacks the final authority to execute those personnel changes without getting upper management approval, they remain an employee under the law.
Wow.
Yeah, they strictly retain their federal shield.
So you can't just be a manager in name only. You need the actual operational teeth.
Precisely.
And there's another fascinating layer to this protection regarding corporate restructuring. The sources detail this concept called the taint theory.
Ah, yes, the taint theory.
Because even if a company claims they're laying you off due to a legitimate reorganization or a lack of work, which is normally allowed, right?
It is, yeah.
If that decision is tainted by even the slightest degree of anti-union animus, or it's an unlawful reprisal for you speaking up, the whole reorganization defense fails completely.
That's exactly right. If a bank claims they are eliminating your department to save money, but the evidence shows they actually just wanted to get rid of you because you were a vocal advocate for better working conditions.
The adjudicator will look right through it.
Right through the restructuring excuse. The federal private sector is highly protective of the worker.
But we need to contrast that with our next environment, because what if, instead of working for a federally regulated private business like an airline, you work for the federal government itself?
That is a very, very different story.
Yeah, so that's how a federal bank teller is treated. But what about the person processing your passport at a government agency in Ottawa? How does the state treat its own direct employees compared to private citizens?
From everything we're looking at, it is a much harsher reality.
It really is.
If you are employed directly by the Government of Canada, you operate under a rigid statutory framework. And the defining feature of this framework is statutory exclusivity.
Meaning you are locked into their internal system.
Completely locked in.
Even if you are a non-unionized federal public servant like one of those excluded managers we just talked about, or, say, a confidential HR specialist who isn't allowed to be in a union, you're statutorily bound to internal employer grievance schemes.
Yes, under the FPSLRA. The Supreme Court ruled on this extensively in Vaughan versus Canada. They established that because the federal statute provides a comprehensive internal grievance scheme, civil courts are completely ousted.
The rationale there is that the government wanted to keep labor disputes within a specialized, streamlined administrative system, right? Rather than clogging up the public court system with thousands of civil service lawsuits.
That's the idea. So, a non-unionized federal public servant who is severely harassed by a director or constructively dismissed cannot just go hire a private employment lawyer and sue the Crown in a regular civil court.
Because the statute legally strips them of that right of action.
Exactly.
But wait, this brings up an original concern I have. If you can't sue in court, who acts as the neutral referee?
Well,
Like, say my boss at a federal agency treats me unfairly. I file an internal grievance, it goes up the chain of command, and the department head ultimately signs off saying, nope, we looked into it and we did nothing wrong. Where do I appeal outside of the department?
this reveals a truly terrifying administrative vacuum for these unrepresented government workers.
Terrifying is the right word.
Because if a unionized worker files a grievance, their union can eventually escalate it to an independent third-party arbitrator. But an unrepresented federal worker can only escalate their grievance to the Independent Labor Board if it meets incredibly strict statutory criteria.
Like, what kind of criteria? Are we talking about basic fairness?
No, essentially it has to be severe discipline. We're talking about termination, a massive suspension, or a direct financial penalty.
Okay, but what about standard disputes?
For standard workplace disputes like unfair performance evaluations, being denied training, toxic bullying that doesn't result in a firing, or minor punitive deployments to different offices, the internal decision of the final level management is legally binding.
Wait, really? So the civil courts have no jurisdiction, and the Independent Labor Board has no jurisdiction to hear it either?
That's right. The employer investigates themselves, finds they did nothing wrong, and that is the absolute end of the road.
You just have to live with it or quit.
Basically, yes.
That is a massive loss of power for the individual worker. But let's pivot sharply and look at provincial public servants, because the reality there is completely different.
It's like night and day.
Right. If we use Ontario as the prime example, does the provincial government treat its people the same way Ottawa does?
Not at all. The legal reality of an Ontario provincial public servant contrasts sharply with their federal counterparts.
Though it's worth noting that Ontario does do something very specific regarding employment standards. Yes.
Yes. By provincial regulation, Regulation 28501 specifically, the government actually strips away almost all major statutory protections. Things like minimum wage, overtime pay, and limits on hours of work.
They just strip them away for direct civil servants.
Yeah.
Which sounds terrible at first glance, but the rationale in the sources is that the vast majority of provincial civil servants are heavily unionized. So the government just assumes they will negotiate those specific terms directly in their collective agreements.
Exactly. Yeah. But the critical distinction lies in how Ontario treats its non-unionized staff, the unrepresented managers and directors within the provincial ministries.
Right.
While the federal government explicitly passed a law blocking civil court access, the Ontario legislature never passed a statute barring their unrepresented workers from court.
Which gives them a massive legal advantage. Because the Supreme Court established in a case called Wells versus Newfoundland that at common law, the provincial crown is actually treated as a regular commercial employer.
And that was a huge shift in the law.
Why is that?
Because for a long time, there was this antiquated, centuries-old legal doctrine that crown servants just held their office at the pleasure of the crown.
Meaning the king or the government could just dismiss them on a total whim.
Yes, without a dime of compensation. But the courts firmly rejected that. They modernized it. Because there's no specific law explicitly barring them, non-unionized Ontario public servants retain their full common law right to sue the government in the Superior Court of Justice.
Just like a private citizen suing a private company.
Exactly.
Okay, here's where it gets really interesting. Because we've established that non-unionized provincial public servants and those excluded managers in the private sector are heavily relying on the civil court system.
Right.
So we need to look at the massive legal weapons they use when they actually get into a courtroom. There is a fascinating legal doctrine that comes up constantly when these unrepresented workers sue for severance, often referred to by the landmark case, Waksdale versus Swagan.
Oh, Waksdale. Yes, this doctrine completely shifted the balance of power in employment contracts across the province, and honestly, it's influenced law across the country.
I like to think of this doctrine like a high-stakes game of Jenga.
Okay, how so?
Well, when you sign an employment contract on your first day, there's almost always a termination clause buried in the back, right?
Yeah.
And it's designed to severely limit your severance if they ever let you go. But under this Waksdale doctrine, if the employer pulls out one bad block, say, they wrote a tiny little for-cause clause somewhere in the fine print that happens to violate the absolute minimum standards of the Employment Standards Act. The entire termination contract comes crashing down from inception. The whole thing is void.
That is actually a very accurate analogy. The courts basically took an all-or-nothing approach. If any single part of the termination clause is illegal, even a part they aren't relying on to fire you today, the entire clause is unenforceable.
And the reason the courts did this is vital.
Right. Very vital. Because if they just allowed employers to sever the illegal sentence and keep the rest of the contract, employers would constantly write illegal, highly oppressive clauses.
Hoping you just don't notice.
Right. Knowing the absolute worst-case scenario is that a judge just crosses out one line and enforces the rest.
So it creates a massive deterrent against writing bad contracts. And the result for the worker is incredible. Because the contract is voided, the worker doesn't just get the minimum statutory severance.
No, they default to common law reasonable notice,
which can completely skyrocket their payout.
We are talking about a severance package jumping from a few guaranteed weeks under that voided contract to potentially up to 24 months of full pay.
24 months.
Yeah, based on their age, their tenure at the company, and the seniority of their position.
But what if you aren't explicitly fired? Like, what if the company realizes it would cost 24 months of pay to fire you, so instead they just make your daily life so miserable you are forced to quit?
Then we enter the realm of constructive dismissal.
Okay, how does that work?
The courts have established a very specific two-branch test, often citing the Potter case, to determine if you've been constructively dismissed. Branch 1 is a single substantial breach of an essential term of your contract.
Give me an example.
For example, placing an executive on an indefinite administrative suspension without pay. That has been deemed a fundamental breach. You didn't agree to work for free, so the employer has effectively broken the contract.
Okay, and what is the second branch?
Branch 2 is cumulative conduct. This is where there might not be one single explosive breach, but there is a sustained toxic course of conduct over time.
Like death by 1,000 cuts.
Exactly. Imagine a scenario where a manager slowly strips away your direct reports, physically moves your desk into a supply closet, and consistently berates you in front of colleagues. That cumulative behavior demonstrates the employer essentially no longer intends to be bound by a professional employment contract.
Let me push back with a real-world scenario based on this framework. What if the boss doesn't suspend you, and they aren't necessarily toxic every day, but they just dock your pay to cover a mistake you made? Say a piece of expensive equipment breaks while you're using it, and the boss just takes the cost out of your next check. You still have your job, right? Are you constructively dismissed?
Well, if we look at the underlying mechanics of contract law, particularly cases like Rothberger versus Concord, the courts have been very clear on this. Unilaterally deducting funds from a paycheck without explicit written authorization from the employee.
Even to recover alleged losses or damages.
Even then, it constitutes a significant fundamental breach of the contract.
So you can just walk away right then and claim full severance?
Yes. That unauthorized reduction in your pay immediately crystallizes a claim for constructive dismissal under Branch 1.
Wow!
And when you win in court, the judge will make you whole. You get your full common law severance, your lost salary, any non-discretionary bonuses you would have earned during that notice period, and even things like vesting stock options that would have materialized if they hadn't forced you out.
That is huge. Okay, but everything we've talked about so far is highly individualistic. You know, suing your boss, navigating your own contract, getting your own severance. But what happens when an employee trades all of those individual rights for the power of the collective?
The unionized worker.
Exactly. The final jurisdictional area we need to look at is the unionized worker.
Right. When you elect to unionize, the legal paradigm shifts entirely. You trade individual autonomy for collective strength. You lose the right to negotiate personal bonuses, you cannot negotiate an individual contract, and you absolutely cannot sue your employer in civil court for wrongful dismissal.
But in exchange, you gain massive collective bargaining power and the vital protection of a strict just cause standard for discipline across the board.
Yes, and this introduces the exclusive jurisdiction model. The Supreme Court established decades ago in the Weber case that labor arbitrators possess exclusive authority to resolve any dispute arising from a collective agreement.
So civil courts are entirely ousted from union disputes.
Completely. But the Supreme Court expanded this incredibly far in subsequent rulings, like Perry Sound. They declared that the substantive rights of human rights codes are implicitly incorporated into every single collective agreement in Canada.
That feels like a monumental decision.
It really was. The logic was that the courts did not want parallel legal systems where a worker fights a firing at a labor arbitrator, but fights the discrimination that led to the firing at a human rights tribunal. They wanted one unified forum.
Right, so the labor arbitrator doesn't just handle union rules about seniority or overtime. They are legally mandated to enforce human rights laws directly.
As if the Human Rights Code was written into the union contract itself.
Which sounds efficient on paper, but it raises a very dark dilemma for marginalized workers.
It does.
So what does this all mean for a marginalized worker? If the union legally owns the grievance process and an individual worker faces terrible racial or gender discrimination, what happens if the union looks at the case and simply refuses to spend the thousands of dollars required to take it to arbitration? Isn't that worker just legally trapped?
They are. I mean, they can't sue in civil court, and their union won't help them. This is a major national dilemma, and the Supreme Court, in the Horrocks decision, ruled that, generally speaking, the labor arbitrator does have exclusive jurisdiction over human rights complaints, too.
So in most of the country, that unionized worker is blocked from going to a provincial human rights tribunal on their own.
Yes.
So what is their only legal recourse?
Their only remedy is to file a duty of fair representation complaint against their own union.
They have to put their own union on trial.
Essentially, yes.
Yeah.
And this is a notoriously difficult legal bar to clear. You have to prove the union acted in a manner that was arbitrary, discriminatory, or in bad faith. Simple negligence, like the union rep just doing a bad job investigating, isn't enough.
Oh, wow. It leaves a lot of vulnerable workers stranded without a voice.
It does. But what's fascinating here is that there is a massive exception to this rule.
Specifically in Ontario, right?
Yes, the province of Ontario represents a profound exception. Under what's known as the Wild Gosh Doctrine, the Human Rights Tribunal of Ontario looked at the specific wording of the Provincial Human Rights Code and ruled that the legislature purposefully included language that creates concurrent jurisdiction.
Meaning they override the exclusive union jurisdiction?
Exactly. So if you are a unionized worker in Ontario and your union refuses to file a human rights grievance for you, you can completely bypass your union.
You don't have to fight them on that impossible duty of fair representation standard.
Nope. You can file an individual discrimination claim directly with the Human Rights Tribunal yourself.
Provided you follow the parameters, I'm assuming.
Yes, there is no double dipping allowed.
Yeah.
You can't have an active union grievance and a Human Rights Tribunal claim running at the exact same time. And you still have to meet the standard one-year limitation period to file. But ultimately, this preserves an individualized avenue to justice for unionized workers in Ontario that simply doesn't exist in much of the rest of the country.
It's incredible how much your geography and your classification change the rules of the game. Now, despite all these different jurisdictional labyrinths we've walked through, there are some baseline fundamental rights that seem to cut across everything, regardless of your bucket.
Yes, definitely. Certain human rights protections are universal across Canada. For instance, medical accommodations in the workplace.
Okay, how does that work universally?
Under federal and provincial human rights codes, all employers must accommodate disabled employees to the point of undue hardship.
And the really crucial detail here is how the law balances medical privacy with business needs, right?
Yeah.
Because an employer cannot demand intrusive medical diagnoses.
Never.
They do not have the right to know your specific psychiatric condition or the exact nature of your physical illness. They are only entitled to functional medical information.
Exactly. The focus is entirely on functionality, not diagnosis. The employer needs to know, what are your actual capabilities, what are your limitations, what are your specific return to work requirements so they can modify your desk or your schedule.
Because the employer is not a doctor.
Right. They only need enough information to adapt the work environment. The other major universal protection involves workplace harassment.
Right. Provincial statutes like Ontario's OHSA require employers to actively investigate all complaints of workplace harassment. It's not optional.
And an employer's failure to conduct an impartial, thorough investigation can independently trigger that constructive dismissal claim we discussed earlier.
Because by ignoring harassment, the employer is failing to provide a safe work environment.
Exactly. Which is a fundamental breach of the employment contract, regardless of whether you are unionized, federal, or provincial.
There is also a really important procedural mechanic regarding retaliation here. If you report harassment or you refuse unsafe work and you suddenly get fired 2 weeks later, that's an unlawful reprisal. But the legal burden of proof actually flips.
Yes. This is known as a reverse onus.
I found this part fascinating.
It is. Normally, the person suing has to prove their case. But in these specific reprisal proceedings, the employee doesn't have to prove they were fired because they complained.
The law recognizes that the employer holds all the internal emails, the meeting notes, and the real reasons for the firing.
Exactly. So the employer has to prove, unequivocally, that the termination was completely, 100% untainted by any retaliatory intent. It is a very difficult burden for an employer to meet if the timing of the firing looks suspicious.
We have covered an immense amount of ground today, so depending on where you sit, if you are at a federal bank leveraging statutory job protection, a federal ministry trapped in an internal grievance loop, an Ontario ministry using the Jenga strategy in civil court, or bypassing your union entirely for a human rights issue, your legal reality is completely different.
Totally different.
Identifying your specific classification is the absolute first step before you sign a contract, accept a severance offer, or file a lawsuit.
It is the foundation of knowing your rights. If you don't know your jurisdiction, you don't know your legal standing.
But before we wrap up, I want to leave you with a brand new thought to chew on, building on exactly what we discussed in that first segment about managers.
Okay, let's hear it.
Remember the strict operational reality test. To be excluded from protections, a human manager must have the autonomous power to execute fundamental decisions, independently hiring, firing, and allocating budget. But look at where the modern workplace is heading.
Ah, I see where you're going with this.
Right. Corporations are increasingly deploying AI and algorithmic management to monitor workflows, auto-generate performance reviews, and in some cases, automatically trigger discipline or terminations based on productivity metrics.
That fundamentally changes the operational reality test we talked about.
Yeah.
If the algorithm is the entity actually evaluating the metrics and making the final call on who gets fired, the human being is no longer exercising independent autonomy.
Exactly. If a human middle manager is just receiving a prompt on a dashboard and clicking approve on an AI's automated termination sequence, do they lose their legal status as a manager?
That is a wild thought.
Does an entire tier of corporate middle management legally revert back to being highly protected employees under the law simply because the algorithm took away their autonomy?
It's a brilliant legal frontier. If the machine is acting as the true manager, the human is essentially just an administrator carrying out the machine's will. And as we established, administrators are employees.
Right.
Courts are going to have to decide if delegating authority to software legally strips a company of its managerial exclusions. I think it'd be fascinating to watch.
The rules of the workplace are changing faster than ever, and knowing exactly where you stand might just save your career.